I'm thrilled to kick off day 4 of this 6th annual review with our session 12 on False Claims Act, Foreign Corrupt Practices Act topics. Our panel members include Andy Liu, the founding partner of Nichols Liu, and Andy is also a principal with the Contractor Integrity Solutions, where he monitors performance and performs ethics and compliance monitoring. Next, we have Justin Chiarotto. Justin is a partner and chair of the government contracts practice at Blank Rome. Next is Jennifer Short, who is a partner at Kaiser Dillon in Washington. Jennifer is former assistant U.S. attorney for the District of Columbia. And last but certainly not least, Bob Rode. Bob is also a partner with Nichols Liu. So looking forward to the program. Andy, may I turn it over to you to get us started?
That would be great. Thank you very much, Alan. It's a pleasure to be here with you all again this year. So we have just a little under 2 hours to cover a year's worth of developments in the area of fraud and enforcement. And that's about double what we've had in past years, but we could probably still spend the entire day talking about this. So my fellow panelists and I have done our best to try to identify the top developments that we could cover in 2 hours. We hope you will find what we've selected interesting. So here's a roadmap of what we are going to cover today. We're going to start off with the False Claims Act and the last year's developments before turning to the more recent DOJ guidance that has come out in the last year, and then talk about criminal developments, including both procurement fraud and the Foreign Corrupt Practices Act. And then probably most interesting will be our views on the trends and the forecast for 2021 and what this year will look like. So with that, I'm going to ask Bob to kick it off. He's going to cover the 2020 FCA statistics, which finally came out a few weeks ago.
All right. Thanks, Andy, very much. And thanks, everyone, for attending and participating today. I am kind of a geek when it comes to the FCA stats that come out every year. And I've been cautioned to be limited in my remarks in covering them, so I'll do my best. And I think Andy is concerned that we have 2 hours, and I'll take up most of that time on the stats alone. But I'm going to try to get through them quickly and really start out by covering general observations, some of the industry enforcement numbers and how those shape up between really healthcare and defense and other industries, the key TAM or whistleblower versus non-whistleblower cases, and some of the things that may not be apparent in the stats themselves. As many of you are aware, every year DOJ comes out with their FCA stats from the prior fiscal year. Sometimes they come out in November or December, but this year, like last year, they came out a bit later in January, actually just about a week ago. We all speculate as to why that is. My view is that when the stats tend to be less good for DOJ, they tend to be a little delayed in coming out. That's what happened last year. And I think that's what happened this year. The department always likes to tout its results in superlative terms. And this year, the results for DOJ, at least on their face, and we'll drill down a little bit, didn't appear to be that great. They were superlative in some respects, but perhaps not for the reasons DOJ had hoped for. And so we'll talk about that a little bit. In FY 2020, the department raked in just $2.2 billion from FCA cases. That number may seem like a lot, but in the context of what we've seen over the last few decades, it's really quite small. In fact, it's the lowest haul in over a decade, since 2008. It's also notable that it's down nearly $1 billion from the $3.1 billion in 2019. And even 2019 was pretty much a ho-hum year. What's interesting is the decade that preceded this, which was went gangbusters by all measures. There was $38 billion in that decade. I'll call it the 2010s decade. Double the amount from any prior decade, and clearly the most robust period ever, largely due to probably FARA and the ACA. Now, the question is what does this mean, and what does it mean for the future? Questions arise as to whether the pandemic had an effect. But what's interesting to note is that the stats are deceptive for reasons we'll get into in later topics to be covered today. The number of cases filed is what's startling to me in terms of the hopper or the pipeline. There was over 900 total cases filed in 2020, and that's the highest ever. DOJ had 250, which was a 70% jump from the year prior. And the number of Ketam whistleblower initiated cases was over 670. So that's pretty significant, and it portends a pipeline that will mean 2021 will be very robust. So in terms of the industry, and let's look to see what was done with various industries. It's clear that there was no sharp rise in any particular industry, but healthcare, not surprisingly, continued to dominate. There was a record number, roughly 570 of new FCA matters involving healthcare. It's the fourth highest Ketam matters, 450 in healthcare. And most of these were kickback focused under the anti-kickback statute. And that's a trend that we're seeing. Many of the cases involve some large settlements. And it's worth noting here that what didn't get reported in the statistics was a very significant settlement that couldn't be captured because it's going to happen after the fiscal year. And that's the Purdue case, where Purdue has agreed to pay $2.8 billion to resolve False Claims Act cases. But those settlement discussions were still live in October, and so they'll get reported in the 2021 stats. So again, the stats are a little bit deceptive. So again, the healthcare constituted 80% of all of the recoveries under the False Claims Act. In terms of defense, it was one of the lowest as defenses continue to plummet steadily over the years. It was about 3% of recoveries, or about $75 million, even down in the prior year, and the lowest since 2014. In terms of Ketam versus non-TCAM cases, there were a record number of new Ketam cases filed, and I can't emphasize that enough. So even though the overall recoveries were low for 2020, the number of cases was huge. And there were, again, 250 initiated by DOJ, but over 670 initiated by whistleblowers. And the other thing that's notable, even if we're looking at the numbers of the recoveries, the 2.2 False Claims Act recoveries, 1.6 billion of that came from Ketam initiated actions. And I know you all are dying to know, but the relators got $309 million in their pockets as a result of that. So lastly, those are some of the trends, kind of what we've seen. And now I'd like to just briefly say what the stats don't show us and what we might see, or what the takeaways are. First of all, the stats don't show us mixed recoveries. When you have federal and state combined cases, typically Medicaid is a good example of that. So the numbers might seem deflated. They don't show us those that are closed without any kind of recovery. They don't show us the number of cases that are dismissed, how they're dismissed and at what stage. This is obviously important as we're looking at the Granston Memo and the effect that that's have. Basically, the Granston Memo encourages government voluntary dismissals of non-intervened cases. And they don't show us the number of qui tam cases that have been filed where they've failed to recover any money whatsoever. As to that, the stat stays pretty constant that of all of the qui tam cases that are filed, the government intervenes in roughly 20%. But of those 20%, the government and the relators are successful about 90% of the time. Whereas in the 80% in which there is no intervention, the relator going it alone is only successful about 15 to 20% of the time. So lastly, in terms of the Granston Memo, we'll talk about that in greater detail. It's worth noting that it's being exercised, but it doesn't look like that's having any deterrence on the number of cases filing. Obviously, there's been a record of new cases filed. We'll see what happens and whether or not the pandemic spending of over $1 trillion is going to increase even further the number of cases that are filed that could be pandemic related. Lastly, I would just note that when the DOJ did announce the statistics, they were defensive about 2020, but very bullish on 2021. So take a deep breath for 2020, but buckle up for 2021. Thanks, Sandy.
Thanks, Bob. Not sure if our video is on, but we'll
get you in a second. We're working on it.
All right. Thanks. So, the statistics are always interesting, and we're always trying to figure out what story they tell. I for one, don't believe that the drop in numbers really says much. I think that if you look at past years, numbers get skewed by, very large settlements, whether in the healthcare area, the housing area, or what have you. And this year, maybe it's due to the timing of when the opioid settlement took place. But we will see what happens in 2021. So with that, I'm going to turn it over to Justin, who's going to talk about some interesting cases on objective falsity.
Super. Thanks, Andy. Looking forward to working with you guys over the next couple hours. I know the stats will be very interesting to see. I think, the thing that really popped out to me is obviously this rise in government initiated cases. So a big pipeline that we've all kind of anticipated coming down the road with the CARES Act and relief programs that, bears a pretty serious omen for,
I think that's right.
For folks out there in 2021 and beyond. So we'll talk a little bit here quickly on an emerging circuit split relating to objective falsity. These are cases that all arise in the healthcare arena and involve, I think some issues that are a bit unique to that area, but we can extend the principles a little bit. I think we will see in these cases into the procurement arena as well. So this, of course, will start with a case that's well known to many folks in the audience today, which is the U.S. versus AseraCare. This is the 11th Circuit decision that followed a fairly long district court proceeding and case history relating to eligibility for hospice services. So a lot of folks were waiting for this decision to drop. And at issue in that case was the issue of whether competing medical opinions relating to eligibility for hospice could give rise to potential falsity under the False Claims Act. And there you had basically a difference of view between two experts as to whether or not patients that had been put forward for this eligibility qualified for hospice care. So the district court threw that decision out, finding that there really wasn't a basis there, that the government couldn't prove objective falsity given the nature of the admission requirements and the nature of the opinions. And the 11th Circuit also found, holding that there was no requirement, that the objective falsity requirement, a reasonable disagreement was typically insufficient to establish a clinically false judgment. So where there's no other evidence of falsity. I mean, that's not to say that there could never be a potential false claim if somebody was intentionally trying to defraud the program, but a reasonable disagreement between medical opinions typically insufficient to establish falsity. So a lot of excitement in the defense bar about that opinion. Not surprisingly, the government had a different view about how far that should be extended, and a lot of plaintiffs also disagreed. And you see in a couple of other cases sort of a different trend emerging. U.S. ex rel Druding versus Care Alternatives out of the Third Circuit, and then U.S. ex rel Winter versus Gardens Regional Hospital out of the Ninth Circuit. Slightly different facts here in Druding. This was another hospice care case, and the underlying facts there basically challenged a number of the certifications for eligibility there and whether or not there was sufficient information to support an end-of-life determination in a hospice case. Here, the court found, unlike AseraCare, that a physician's judgment can be scrutinized and considered false. So even if there's a difference of medical opinion, that can create a triable issue of fact, allowing a case to proceed forward. A couple of things singled out there were patients admitted for psychiatric diagnoses, even though there wasn't a psychiatric hospital. And then, of course, for a couple of other patients, there was actually no diagnosis of a psychiatric issue. So those types of facts, in the court's view, supported the determination that you could have a triable issue of fact and the case move forward. In the similar vein, Care Alternatives. And I should note, importantly on Care Alternatives, that is on a cert petition now to the Supreme Court, which was filed late last year. So it'll be interesting to see if they take that up. The Supreme Court has tiptoed around a lot of these cases recently, but it will be interesting to see given the circuit split. And then Winter in the Ninth Circuit, similar outcome. Inpatient hospitalization determinations were on the table here. Again, they viewed their decision here, finding that you can have falsity in a case proceed where there's a difference of view. A medical opinion has got to be judged just like any other representation, right, according to the circuit. They view that as in harmony with AseraCare. The Ninth Circuit said that. So you really need to look at the underlying program, the terms of that program, what sort of judgment or discretion is afforded to a physician in establishing that eligibility. So in their mind, the hospice regulations at issue in AseraCare provided for a lot more discretion and therefore a lot more flexibility that you look at through the lens of scienter and materiality. The Justice Department applauds that. They filed amicus petitions in both cases. But reinforcing, I think, the complexity here, there, as much as we all like certainty in this business and, is there a bright line rule? It's hard to find. A lot of these cases are very fact bound. The regulations are very fact bound. Folks dealing with these issues in the procurement world see these same issues all the time, right? What sort of discretion is afforded in a regulation? How is it exercised? And how does that inform how you plead or defend against the critical issues of materiality and scienter under the False Claims Act and Escobar? So very interesting to see how that one moves forward.
So these three cases are all arose kind of in the healthcare context, right? But I think the same principles really around objective falsity apply in the more traditional government contracts procurement area, right?
Absolutely. We could spend all day talking about how individual regulatory regimes, and we'll talk about some later today, looking at the crystal ball, provide for that discretion, provide for waivers. What sort of authority does a contracting officer have to waive a requirement, right, let's just say, and what do the facts show in setting that up?
Or even on just the interpretation of regulations and statutes. I mean, I think these cases kind of, remind me back of the Safeco case that Supreme Court decided in a different context. Safeco had to do with, I believe it was the Fair Credit Reporting Act, but there's parallels because the Fair Credit Reporting Act, defined what was at issue in that case was whether the defendant willfully, right, committed a violation, and the standard there was reckless disregard, as it is in under the False Claims Act, and the Supreme Court, found that objectively reasonable interpretations, even if at the end of the day wrong, negate the scienter element. And so, to me, the AseraCare ruling is the correct decision under the Supreme Court precedent, but we'll see whether the Supreme Court picks this case up.
No, it's an important one, and obviously for defendants out there, how can I manage my business risk, right, with some certainty about these issues? A lot of these things are very interesting. They're very academic. there's a lot of time for Andy, you and I, and Jennifer and Bob to spend, thinking about these issues and briefing them. But it's incredibly disruptive, right, for the business. So how do you manage consistent with the expectations that the regulators have in setting these frameworks up in a way that doesn't disrupt the whole business operation? So
exactly. And Jennifer and Bob will feel free to chime in on any of this as you would like. So,
well, I'll chime in for just a second on the AseraCare case. Both is an interesting twist on what happened at the trial court level in that case. The case actually did go to trial in front of a jury, and in spirit of candor, I was with the U.S. Attorney's Office at the time, and I knew a number of people at DOJ who were on that trial team. The judge in that case agreed to bifurcate the trial in AseraCare and split, not the typical split that we see when we go to trial of let's try liability and then do damages as a part two. In AseraCare, the judge said, we're going to look at objective falsity, one of the elements under the False Claims Act, as a standalone triable issue. And then if the government can prove falsity, then we'll get to the scienter and other elements of the False Claims Act. And I think that sort of plays into the way that this issue has been framed, because as those of us who practice in this area know, there's a lot of interplay between the elements and how the courts even talk about. Now we're talking about the falsity issue. This goes to scienter, and the way that we break those down. So I think in AseraCare, it was very beneficial to the defense, and something for us to think about going forward on the defense side, to be able to try to cordon off each of those elements. How is the government here proving falsity? How is the government here proving knowledge? And to look at each element sort of separately and parse it out as best we can. So we'll see, but it'll be interesting, and it'll be interesting to see if the Supreme Court chimes in and talks to us more about objective falsity and what does that mean.
Yes, I think we're all anxiously awaiting what they'll do.
Well, I'll just add as
denied, leaving us all in the dark. We'll see.
I think as a practical matter, there was some hopes for us on the defense side, particularly in the medical healthcare context case, where you could use AseraCare and the principle of objective falsity or negating falsity by having two differing or competing opinions as something where you could dispose of a case
Early.
very early, right? And I think what there's a tendency to do is we're back at a point where there's an understandable conflation of objective falsity and scienter, because it's not merely that you have two experts, qualified experts, who come to diverse opinions that would render something objectively false. There needs to be further inquiry to go into a little bit of scienter. One part of that is to determine what's the basis for the opinion. Was it, it's like a legal opinion where you provided all of the relevant facts in circumstances before rendering that opinion, or is it infirm? That goes to the issue of whether you can attack the expert's credibility at trial. And then second would be the scienter, which is what if the competing opinions may be grounded in fact, but they were known to be false at the time they were made or at the time the claims were submitted to the government. So it seems like we're getting back into this won't be a clean early dispositive motion issue. At the very least, it will require some evidentiary presentation to the courts, summary judgment, and probably trial in some instances.
Great. Thanks, Bob. So I think we'll turn to the next slide and the next topic that Jen is going to kick us off on.
Sure. Let's talk about data mining. So this is not necessarily new, although in recent years there have been more whistleblowers, more relators bringing cases based upon data analytics. So that's why data mining has gotten a lot of attention among the bar, because of these outsider relators bringing cases where they're not really your prototypical whistleblower, insider, somebody that has knowledge of the actual practices of a company. So that's gotten attention. But I think, especially for this crowd, the big takeaway is that data mining and data analytics has been mentioned in almost every DOJ public remark or press release that relates to a DOJ priority throughout 2020, and even dating back into previous years, where DOJ is saying we are using data mining and data analytics to help us identify potential fraud. So I think that's the big warning to folks in thinking about what is the information and the analytics, the data that the government can access, and how is it looking at that, and where does that present business risk? I think the most recent to today's discussion was Michael Granston's remarks to the ABA back in mid-December of last year. And he again mentioned, this is how we plan to start developing cases. I'll just add to that, as many of you know, there's been a leadership change at DOJ Civil Frauds, and one of the deputy directors who's there now has sort of made a name for himself and a reputation for himself by doing a lot of data mining in the healthcare field. I anticipate that that's going to expand as an investigative tool and a way for DOJ to start digging in to some new cases, back to the statistics of the new matters that DOJ opened in 2020. Separately from using data analytics as an issue spotting, potential fraud spotting tool, then you get into these two IntegraMed cases that came to very different results. And just by way of a little bit of background, so IntegraMed Analytics is a company that used access that it had to Medicare data, the government's Medicare database, along with some other pieces. And they basically crunched the numbers and analyzed the numbers and identified outliers in the hospital context, primarily looking at patterns and practices, things that looked like upcoding of diagnoses. And they used those statistics and to go ahead and file key tam actions against the entities that were sort of the outliers. And the government declined these two cases, the Baylor case and the Providence Health case. So these are declined key tam actions where IntegraMed went ahead and pursued the case without the government. And in the Baylor case in Texas, the district court, on a motion to dismiss, basically came down on the side of, hey, look, this doesn't meet, frankly, the court said this doesn't even meet Rule 8 standards, because there is the reasoning there, and then the reasoning that the Fifth Circuit used affirming the dismissal of the action. The statistics alone showing that Baylor was an outlier in its coding practices, there was a plausible explanation or reasonable alternative explanation for that data. And interestingly, on a motion to dismiss, Baylor presented their alternative rationale for why the statistics didn't necessarily show that they were an outlier and engaging in improper upcoding. In fact, the argument sort of went that they were super compliant because they pulled in some CMS guidance that had come out right when the analytics showed that their coding shot way up and they became outliers. Well, right at the same time, CMS changed its systems a little bit and had issued guidance to say, hey, we're changing our systems, but we anticipate that we're going to see more of this secondary coding and that actually reimbursements are going to go up, and we want hospitals to do this and, have at it. So that decision and the decision at the Fifth Circuit really focused on, is it enough to show falsity, that element of falsity, based solely on these statistics and on this defendant being an outlier? And in that case, the district court and the Fifth Circuit came out and said, like, look, this just doesn't show false. It's just numbers. You can't reach a conclusion based on the statistics here. In the Providence Health case, the court came out differently. A lot of the decision that at the district court level focused on an argument that the defense had that, hey, all of this information was publicly available. So they looked at the public disclosure bar of the FCA to say, this case should be thrown out because IntegraMed didn't really do anything except take publicly available information that frankly came from the government, slapped an FCA label on it, and they really don't have anything else to add. They should be booted out. Defendants also raised the issue of falsity. And on both fronts, the district court there said, we're going to let this go by, especially at the motion to dismiss stage. And interestingly, the district court said, so the statistics don't definitively prove that fraud was occurring, but hey, this is a motion to dismiss, and we're looking at the pleadings and we give the plaintiff the benefit of the doubt. And also, interestingly, that court looked at guidance that had come from CMS about how the government uses data analytics to identify indicators of fraud. And they said, hey, we're going to give you the benefit of the doubt. And so you're getting past a motion to dismiss, and we're going to let this case go forward using the statistics. So just interesting, different results and different approaches from the courts, and both relying on guidance that came from the agency that benefited one side or the other. The Providence Health case is now on appeal, and arguments are scheduled for the Ninth Circuit next month. Bottom line, I think for this crowd, for contractors, again, thinking about what data is going to be available or potentially available to these data analytics groups, whether it's data analysts working at within the government to identify potential fraud, or perhaps these third parties like IntegraMed. Under the CARES Act, a lot of data is being put out there and being published. So that information is out there. So folks who got PPP loans, bottom line, big picture numbers on 3610 spending under the CARES Act. So those are going to provide some additional data sets and data points where we might see some activity on this front. I'm going to pass it back to Bob. He might have a thing or two to say about it.
Well, on the data mining issue, I think especially on the publicly available data, I am interested to see what happens with respect to the public disclosure arguments, right? Because a lot of that data isn't going to be in one of the enumerated ways that trigger the public disclosure bar. But I don't see how those sorts of suits are not parasitic in the sense that the government has that information, and as you pointed out, Jen, the government already has people in-house within the department who are focused on identifying fraud through data mining. Yeah. And so now you're going to have relators, who may be a little bit faster, right, to get and file something, and that are going to take a percentage of that recovery. And it's hard for me to figure out how to reconcile that with protecting the public fisc, right? Which is what the FCA is about. So I don't know whether there's any appetite for reforming the public disclosure bar again, but we'll see.
I do have a couple comments on that. Not surprisingly, I'm not a big fan of statistics sampling. I think it can be flawed, but I understand with the volume of data that is involved in these cases, there's really no other way to do it. I tend to think, I don't disagree that if you get to trial, oftentimes the sides will agree on how to pick representative samples, particularly when it comes to a basis for damages calculation. My heartburn, and I think others on the defense side, is using statistical sampling to establish FCA liability. And the larger questions of, is it proper where the statute requires individualized proof of claims with detailed specifics under 9B? Or can you use this broader approach? And if so, what are the quality standards that apply to the samples that are chosen and the methodologies that are used? So I think that there's this openness to using statistical sampling for damages. Certainly, it has a valuable place if you're involved in negotiations with the government. It's where it goes from a negotiation settlement discussion with the government to assess exposure, potential exposure, to actually using it as a means for overcoming dispositive motions and findings of liability at trial. To Andy's point on public disclosure, I think that's a very interesting issue here. As to what relators do and whether the public disclosure applies to those using data that's publicly available is an interesting issue. Where I think this will come out is the relator who uses some kind of proprietary algorithm that they've developed to take raw data that is publicly available, but to convert it into something that's usable for a pleading or for litigation. Is that publicly available if it's the raw data that's publicly available, but then converted to a usable form? I think that's an interesting question, and we'll have to see how that plays out.
Thanks. So let's turn to the next topic, which is Escobar materiality. And Bob is going to kick us off on this one.
Yeah, so when the Escobar case was argued before the Supreme Court, I actually had the opportunity to attend the arguments. I'll say that they were kind of bizarre, and some of the questions that were posed by the justices seemed to have very little bearing to the questions presented or the issues that were briefed. And then when the decision came out, everyone knew it was going to be a landmark decision, but not for the reasons that have ultimately played out. Initially, on the defense side, I wasn't happy with the decision, but then I grew to appreciate that it was actually a very good defense side decision. This notion of materiality and its importance, where the court referred to it as a rigorous and demanding materiality standard the FCA imposes, almost made me laugh, because prior to that, after the amendments of FARA and the ACA, in my view, there was no materiality standard anymore. Turning it into a capable of influence, something that is capable of influencing equals materiality, to me seemed like a non-element. Obviously, the Supreme Court thought differently, and now we have a few years to look back upon. For 2020, a couple of the cases that came out are interesting on that topic. I will note that the emergence of the importance of Escobar really lies, to me, in the if materiality requires there to be some government knowledge, or government knowledge of the alleged falsity is a defense, that by definition opens up and exposes the government to discovery in a way like they've never been exposed before. And that's where I think it's having the biggest impact. That is Escobar, because the government can no longer decline intervention and then sit there with their lottery ticket waiting to see if the relator succeeds. Oftentimes they're met with discovery burdens, which then triggers them to actually think seriously about Granston type dismissals. But as to 2020, the two big Escobar cases, we've listed some, but the two that I wanted to talk about briefly is the Straw case in the Second Circuit, where the court was trying to grapple with the notion of, in the fraudulent inducement theory of FCA liability, where it's alleged that someone made false statements to induce the award of the contract, thereby rendering any claim submitted under that contract false, whether individually, literally false or not. And in essence, the court assessed whether or not the Escobar materiality standard gets applied at the inception of the contract when it was allegedly fraudulently induced, or at the time of the claims submission. Now, the district court dismissed, saying that the focus should be on the point at which the contract was induced. But the Second Circuit said no, that it can apply to both stages. But they're still looking to see, what had the impact on the government, what was allegedly false, and it can happen at either phase of the contract under that theory. The second case is maybe even more interesting. That came out of the Fifth Circuit. That's the Magnolia Health Plan case. And that's a case where the case was dismissed. It had to do with nurse staffing and the number of practical nurses staffed and whether that complied with the law. And if it didn't, those were false claims. Interestingly, the contract itself basically had a boilerplate provision that required the contractor to, quote, follow all laws. And that was the hook the relator had used to try to establish FCA liability. And the Fifth Circuit said no, they affirmed the dismissal. But the interesting part about the decision isn't simply that they said, no, you can't just have this general proposition, because it wasn't material unless they specified which laws and regulations would be applicable. But more important to me is what they said, that you have to look at the course of conduct, meaning if the government knew of the staffing that the defendant was using and didn't object and continued to pay out under that contract, it defeats materiality. They didn't say it negated it, but what they said is the burden increases for the government if there's a pattern by which the government continues to pay, knowing the information that's allegedly false, what we would commonly refer to as the government knowledge defense. So that's the importance of the case law, in my view, under Escobar in 2020.
Thanks, Bob. Jen, did you have something?
Yeah, so just on the point that Bob was just making, I think that's right. And I think that is where we're going to eventually wind up on the government knowledge piece. I think it seems like on Escobar, we really have not touched, or we've only scratched the surface in these post-Escobar cases of where the government has some knowledge, but also may have other reasons to keep paying. So it's materiality is now a rigorous requirement, but there may be this mattered to us as the government payor, but there were other things that took priority. And I don't think the cases have yet really gotten into that issue. We'll see.
I agree with Jen. And I think that, yes, that may be true in a hospital environment where the government knew in Columbus, Ohio, that certain nurses were being staffed with certain qualifications that may not have been appropriate, but continued to pay. Where I think it is different, and I think this is what Jen is talking about, is where you have emergent situations, whether it's a wartime scenario, a natural disaster like a hurricane or a pandemic, where the government is making decisions. I think the government could come back in those scenarios and say, look, we knew and we had issues and problems and heartburn about what the defendant was doing, about the goods or services they were providing, but we needed these a week ago, and we just needed to get the services or the goods to those in need as soon as possible, figuring we would come back and deal with these alleged deficiencies once the dust settles. I can't believe I'm trying to give the government or relators a compelling argument to make, but I think it's the obvious one.
All right, thanks. So let's turn to the next topic, which is attorney-client privilege in the context of mandatory disclosures. So those of you who know me know I'm a huge believer and advocate for the attorney-client privilege in investigations, and believe that maintaining the privilege actually fosters compliance. So I did struggle a little bit with what to make of this case, because on the one hand, it's a hugely important issue. And on the other hand, it seemed to me that the district court so clearly got it wrong in the first instance that how much time do we have to spend on it? But because of the importance, let's talk a little bit about it. So the case is In re Floor Intercontinental out of the Fourth Circuit, but the district court case was Anderson versus Floor. And it's actually not a False Claims Act case. It's a case that was brought by Floor, by Floor's former employee for wrongful termination after Floor had terminated the plaintiff after an internal investigation into an alleged conflict of interest involving that employee and a company to which the company was going to award a contract. So after the company did an investigation, they not only terminated Anderson, but they made a mandatory disclosure to the DOD OIG. And in that disclosure, Floor had made several statements that covered topics that were also covered in the privilege reports that counsel had provided to the company. The district court out of the Eastern District of Virginia found that those statements that were made in the mandatory disclosure resulted in a waiver of privilege. And I think it's important or helpful to talk about what those statements were, because it's critical to the analysis. So the statements that the district court had focused on were, the first is Anderson, who's the former employee. Anderson had a financial interest in and appears to have inappropriately assisted for a Floor supplier and potential subcontractor. The second statement was, Floor considers this a violation of its conflict of interest policy and code of business conduct and ethics. The third is, Anderson used his position as the Afghanistan project manager to pursue Reliant concrete contracts with the German military, and Mr. Anderson used his position as the Afghanistan project manager to obtain and improperly disclose non-public information to Reliant, Reliant being the entity with which there was a conflict of interest. And the fourth is, Floor estimates that there may have been a financial impact to the government. And it goes on a little bit. So the district court found that these were not facts, but were rather, quote, legal conclusions which characterize the plaintiff's conduct in a way that reveals attorney-client communications. And then went on to say that Floor had voluntarily disclosed those privilege statements to the government in its written disclosure. And in Floor's filing of the answer to the complaint, it did characterize the disclosure as voluntary, even though it was made pursuant to the mandatory disclosure rule. And the district court had rejected the argument that the disclosure was not voluntary, in fact, because it was required by the mandatory disclosure rule. So Floor was compelled to produce the privileged materials. Floor filed a petition for a writ of mandamus, which, as most of you know, is quite rare. And the Fourth Circuit granted the writ, heard the case, and found that the statements at issue did not, in fact, reveal any attorney-client privileged communications. And the Fourth Circuit stated what we all know, which is that waiver occurs only if there's a disclosure of actually protected communications. And here, the district court's conclusion that protected communications were disclosed was clearly erroneous, because just because the disclosure that was made to the IG covered the same topics as what the investigation covered, or that the disclosure was made pursuant to advice of counsel, doesn't mean that privileged communications themselves were disclosed. So at the end of the day, it was a victory for the preservation of the attorney-client privilege. I think it's clearly the right decision. And it's got similarities to the Barcode case out of the DC Circuit, which was decided in 2014. Issues were a little bit different in the Barcode case, in that it was a False Claims Act case, and it had more to do with whether the fact that a mandatory disclosure was made meant that the communications were not for the purpose of providing legal advice, but rather for regulatory compliance. And the district court there erred again in finding that there was a waiver of privilege, but the DC Circuit remedied that by saying, no, you can have both, advice that is both for purposes of providing legal advice and for regulatory compliance, which of course is the right outcome. So that was the big privilege case of last year. I should note there was we all still have to be very mindful of, making sure that privilege is not waived. There was a district court case out of Massachusetts that had found that privilege was waived when the company had shared privileged communications with its outside media relations folks, and that constituted actually a waiver. So there's a lot of caution in that area.
Yeah, no, absolutely, Andy. I think it's gotten our attention. Obviously, the right outcome out of the Fourth Circuit, but everybody goes, holy smokes! We really need to pay attention to our internal investigations and disclosure practice. And I also think back to the Martin Marietta decision out of Fourth Circuit, 1988, talking about a waiver where the company had found and waived privilege over protected internal audit materials because they were quoting from those interviews in a submission to the government, and then had waived the privilege and protection over some internal notes and memos because of the way they summarized and presented that information to the government. So really important to be mindful of providing the facts, right, which is the great illusion we have, if you will. We embrace it under Upjohn about sharing information without a waiver. Just a reminder of how incredibly important it is to pay attention and be careful and think through these things before.
And it's not easy.
It's not easy. It is not easy.
So,
There are a lot of fine lines there.
great. So why don't we turn to the next topic, which are CIDs. Jen, I think you're going to cover this. You're on mute.
Sorry about that. So we'll go through this quickly. It's great that there's a new case in 2020 about civil investigative demands, because frankly, there just is very little case law about CIDs. This goes back to, the CID authority in the False Claims Act has existed for a while, but it was expanded with the FCA amendments in 2009, so that the Attorney General could delegate down to different divisions within DOJ, and that authority was further delegated down to the U.S. Attorney's offices. So a CID is now a tool that DOJ attorneys have to go get information from False Claims Act potential defendants. And in this case, in the general medicine case, the CIDs were issued to third parties. So this was an interesting decision because the target of the investigation actually challenged the issuance of CIDs. And it's such an interesting read of a case because you could feel the frustration. And this was a potentially an act of desperation, like I need to get in front of a court, by General Medicine, who came in and said, hey, look, court, the government has been investigating us for 5 years now. And as a result of the government's investigation, poking around and getting a lot of information from us and now going after third parties, we've lost business, we've lost employees, and here they go again, now issuing CIDs to all of our third party, or to a big group of third party business partners of ours, and asking for all of this detailed information. The requests themselves only went back a year. So like, hey, they've been investigating us for 5 years. Now they want to ask all of our business partners, the few that we have left, what were we doing with them last year? And the court was sympathetic. The DOJ came in and said, look, this is a CID under the statute, under the False Claims Act. Only the recipient of the CID can challenge it. And the court, in this circumstance, was pretty sympathetic to General Medicine and said, yeah, no, I think that we can impose some controls here, or you have standing to challenge this because it is having an adverse impact on you. And that was all fine and good. But then at the end of the day, the judge analyzed this as a CID is the equivalent of an administrative subpoena. This was not a case where there was a qui tam action filed, at least that the district court knew about. So this was an open False Claims Act investigation by the government. And the government has pretty broad authority to ask questions and to investigate. Basically, the analysis comes down to, does the request have a law enforcement purpose? And are the questions sufficiently narrowly tailored to reduce any burden on, in the first instance, the third parties, the recipients of the requests, and even here, the burden or the impact that these questions were going to have on the target of the investigation. They're fairly easy hurdles for the government to get over. And so the judge wound up denying the request to quash these CIDs. But it was an interesting setup, and you do feel for this poor company that is just being put through the ringer, and the judge had a few choice words for the government and the length of its investigation on that. So
thanks. I think I love the takeaway of the last bullet point, which is the government authority is not unfettered.
yeah, not totally unfettered, but without the court supervision, pretty broad still.
It is. That's
Yeah.
right. It'll be a good segue into our next topic.
Yeah,
Right.
go Justin. Go Granston.
All right.
Can the government do what it wants on the other end?
All right. Yes, that's right. So we have a birthday to celebrate, a recent birthday to celebrate. 3 years old, the Granston Memo, as of January 10th, 2018 was issued. So for those that aren't familiar with this subject, this relates to the DOJ's dismissal authority under the False Claims Act of 31 USC 3730 C2A. So many colloquially refer to that as a Granston dismissal in light of the memo, but that's the statutory site. So you'll see folks referring to them interchangeably. And so the statute provides that the government can dismiss a False Claims Act suit even over the relator's objection if the relator has notice and an opportunity for a hearing. It does not provide a standard of review. And so the courts have worked to fashion how those requests should be governed. And we'll talk about that briefly here. I'm of the view that the Granston really came out because there were some cases out there that were really leading to some outcomes, bad decisions, bad precedent that were showing the power, the potential perceived power of the law. I think that was a big driver. There are a number of other policy reasons, though, that you'll see behind it. The memo talks about evaluating cases for dismissal under the statute. It has 7 factors. So, you guys pop quiz on this? You guys got any of them? 7 factors under Granston. Curbing meritless qui tam actions, preventing parasitic or opportunistic actions, preventing interference with agency policies and programs, controlling litigation brought on behalf of the U.S., preserving government resources. I'm reading these, by the way, I haven't committed them to memory either. Addressing egregious procedural errors or safeguarding classified information. So those are the 7. And they are now codified at the Justice Manual at 4-4-111. So we'll lays them out. And any one of those, by the way, could be sufficient as a basis for a request for dismissal. So it's a pretty wide range of issues that you could get brought to bear here. There was a lot of controversy about this and interest in it, rightly so, when it came out. And the Attorney General, of course, wrote a letter to Senator Grassley with expressing his grave concerns, which they finally responded to sort of set the table. Bottom line is, is it a huge sea change? Maybe, maybe not. I certainly think it's an important, much more important and focused part of the procedural process. If you look at the numbers, there have been more cases that have been sought for dismissal under Granston in the last 3 years. I think a little bit over 50 or so right now than in the 30 years before its issuance. So, but it's still a small percentage. This is, I think, under 4% or so of the cases have been sought for dismissal, and a number of them involved, not an insignificant number, involved copycat cases in the healthcare arena. But they have been coming in, and there's a circuit split that's emerged on how deferential that standard is. Is it really unfettered, or are there limitations, and how do those play out? So, as we know, we've got the DC Circuit's decision in Swift, which looks at the historical authority that the executive branch is afforded with respect to prosecutions. That looks at an unfettered right. That's an unfettered right standard. So no limitations on the government's ability to dismiss a case. On the other side of the spectrum is the Ninth Circuit's decision in Sequoia Orange. That has that there needs to be a rational relation to a valid U.S. government purpose. So the relator's got to show that the decision essentially was arbitrary or fraudulent or capricious. These are both pretty broad standards. So I think the question will be the practical impact. I think, and we'll talk briefly about the Seventh Circuit's decision here in, I don't know if I can do a pronunciation on this, CINZ NHCA LLC. So a professional relator's operation that was brought a case relating to kickbacks for prescribed medicines. There were allegations that company was improperly providing free education services and paperwork to doctors. The government they did not intervene in the case, but sought to dismiss it under the Granston standards and and the FC dismissal provisions. The district court actually denied the motion. This was in the Southern District of Illinois. They denied the motions to dismiss and found that the government did not satisfy this rational relation test under Sequoia Orange. That they looked at the scope of the government's review, which they thought was very superficial. They thought it was motivated by animus to the relator. Denied the motion. Government, not surprisingly, was unhappy with that outcome, filed an interlocutory appeal, and ultimately the Seventh Circuit weighed in on the government's favor. So they took a slightly different tack and looked at the statutory language, found that their authority there to dismiss was superseded within Rule 41. So they treated the interlocutory appeal and the dismissal request as a Rule 41 motion, a slightly different procedural avenue, but then found that the government had unfettered discretion essentially to dismiss the case. So incredibly broad, and unfortunately for the relator in that case, not a great outcome, but winding up, I think, in the same place, which is very, very significant discretion. Still a small percentage of cases, but I certainly think, and we've seen a lot of clients really taking advantage of this. I mean, it's an opportunity to educate the Justice Department and work with your customer about, is this the right use of your time and resources? And it is in the government's interest. Are we really advancing, the protection of the taxpayer with these cases? So I've certainly seen a lot more attention to Granston as a defense, even if it may be a long shot, and I think it's going to stick around. So.
Yeah, and I think the dismissals really do further the public interest and especially here in the government contracts context where ultimate dismissals, right, on the merits just result in more litigation costs, which are going to be allowable costs, right? If the case is meritless and dismissed, and so it's the taxpayers that are paying
Yep.
for that at the end of the day. So one interesting thing about this is, when this first came out, I had, thought, well, maybe all of these decisions are going to come centralized out of main justice, but that is not the case. So, cases that are, with the local U.S. Attorney's offices, because they're under the dollar threshold that's applied, those decisions can be made just with U.S. Attorney's Office approval. So,
Yeah.
Jen, it looked like you were about to add something.
Yeah, so I agree with you, Andy, on the cost point, which is a good point. And I think one of the things that the False Claims Act enforcement side, they emphasize recoveries to the public fisc and all that sort of thing, but I've not seen good measures of what it costs transactionally or for the government on the other side, where you've got a lot of whistleblower activity and a lot of responding, and that the cost of responding to these investigations is significant, and it's disruptive to business, and it's good for our business as lawyers, but from a systemic standpoint, we're not terribly good, and we don't have our own defense statistics on how much was spent in how much time, money, energy was spent trying to defend and respond to some of these cases. But putting that aside, I think where the Granston Memo standard, where the government is being more proactive about seeking dismissals, I think the concerns are less about the burden on the system, the transactional costs, either to DOJ or to the government or to the defense, but where there's some policy issue. I think there's always a concern that those relator cases, when the relators go forward with a case, there's always concern by DOJ that this is going to create bad law somehow, that the relator isn't carrying the government's water the same way that DOJ would. But for these cases, I think it goes beyond that, where it is, it's not just the cost of responding to discovery or that sort of thing, but where the relator's theory isn't pushing the envelope in a way, or is pushing the envelope in a way that is inconsistent with government policies or agency policies. And I think that's where you see that authority being exercised more freely.
Yeah, I think that's right. And I think that's why you see, DOJ has made it a point to repeatedly say that the discovery burdens on the government are not going to, alone cut it with respect to getting a dismissal. And I think in part that's because they don't want, all of us to just be loading them up on discovery.
Super creative about broad discovery.
Right.
We know how it's done. Yeah, that alone is not going to cut it. But there are some cases, and I wonder how much of this plays into what Bob started us with the decade of the whistleblower and these cases and the massive recoveries and the development of the relator's bar in this space, perhaps willing to take the risk to push the envelope in a certain way. And this may be one way that the government can push back and say, even if you've got a good False Claims Act theory, our agency doesn't want this to happen. So.
Right.
Yeah, and I guess it's my turn. So what I'll say is, when the Granston Memo came out, I was very skeptical, and I think I was, probably others like Andy are in the same boat, where the proof will be in the pudding. Let's see if this actually is put into practice and how many dismissals it actually results in. Part of that was occasioned by the way the memo came out. For those of you who are kind of geeks in this area, it came out kind of accidentally. Then they tried to pull it back, and then it it was in the public domain, and then they just decided to live with it. And what DOJ did, and I understand it, was they were just saying, well, this just really memorializes what our policy has been all along. It enumerates the factors that we look into, but that was generally speaking always, how we approach these things. What's funny is that may be true, but they never exercised that authority, almost literally never exercised that authority in the preceding 30 years. And from 2018, from the date of the Granston Memo forward, there have been over 50 voluntary dismissals by DOJ of qui tam cases. And that number exceeds the prior 30 years combined. So I think that's significant. I think also, if you look at the number, I do think there were like 11 of those cases that were kind of related. So that kind of even puffs up the number of 50. What I find interesting is, I could be wrong, but I think there's only one, maybe two, where the government sought to dismiss, had a hearing before the court, and its efforts to dismiss were denied.
Yeah.
You got to wonder how that happened, I suppose, because you just have to come up with really an articulable, reason that there's a rational basis. So it seems like the threshold for the government is pretty low. But I think more important, why, if you're a relators counsel, why do you want to proceed with a case where the government, the real party in interest, has not only declined to intervene, but has aggressively devoted resources towards dismissing your case? It's just kind of baffling to me why that would, why that would be the case. I'm not sure, maybe Andy or Justin or Jen, if there's not somebody at Main Justice who, at least as a collateral duty, has this area assigned to them, so they can kind of has a centralized, at least, monitoring of these dismissals, that's probably a good thing. But from what I've seen, it's similar to what Andy has seen, which is that different U.S. attorneys' offices handle it differently. Some of them feel autonomous when it comes to making these decisions, although I'm sure they confer with Main Justice. Others will have to move it up to Justice. And then last, I would say on this discovery burden thing, I smile a little bit because be careful what you wish for. With the passage of FARA in 2009 and the Affordable Care Act in 2010, which materially changed the qui tam provisions and made it easier, it really opened up the franchise. And what happened with that was, yes, there were many more whistleblower cases that have been brought, but the quality of those whistleblower cases, is questionable. And I think what the government came to appreciate is, even in a non-intervened case, and Jen can comment on this, I mean, it still takes some work and effort. It's still assigned to an AUSA in the district, and they still have to kind of watch and babysit it a little bit, because of the very reason that a relators counsel might be filing something or taking a position that's associated with the government that's just wrong, or could create bad case law. And just qualitatively, you can look at the stats on this, but there are some firms that are very good relators firms, and they have a super high intervention rate. And then there are some firms that have a 0% intervention rate. And I think this allows for the government to call out the good cases versus the bad cases. And then lastly, with respect to the burden on the government, I just looked to the Gilead case where the government was trying to avoid what it was anticipating as huge discovery burdens because of the materiality government knowledge inquiry that was going to be done. And I believe in their briefing to the Supreme Court said, if you don't take this up, Supreme Court, for these reasons, but even if you do take it up, we're going to dismiss our own case that survived the Ninth Circuit. So there you have it. Those are my thoughts.
All right. Thanks, Bob. So we're going to hit the next topic. I think we're a little bit behind on our planning on the schedule, so we'll try to speed things up to make sure we get to the trends. But Bob's going to give a quick.
Yeah, well, I can catch you up on the schedule because there's virtually nothing to really add in terms of procurement, collusion, strike force developments. The government has continued to give it lip service as being a priority. There are some cases that are being brought purportedly under the guise of the collusion strike force. Some of the staffing has changed. I mean, I think it's not that it's been overtaken by events of the pandemic or other events, but like many strike forces, the inception and the idea for it is great to cut out collusion, big rigging, et cetera, in the government contract space. But what happens over time when you have disparate accountability, sometimes it's not until a year marker comes up or 2-year markers come up and there's a need to post statistics that you'll find more activity. As a defense counsel, I find it frustrating because I've been on the other side of a negotiating table with the government who has all but said to me that, yeah, we might offer an alternative resolution to your case, Bob, but we need, I don't know. I mean, it comes across to me as though they need the statistic, they need a pelt to nail to the wall, and that's influencing their decision making. And I'm saying, I'm not suggesting that the people with whom I deal sometimes are not honorable. They absolutely are. But it's clear that the statistics in the performance of a strike force are something that bears upon their mind, and unfortunately sometimes infects the discussions. So that's all I have.
Bob, I'm curious, in those cases where you're dealing with the strike force folks, how fluent are they in procurement and procurement policies? In talking to some people, some of the folks that were pulled into the strike force, the expanded member group, it seemed like they had, about a year ago, they had a pretty steep learning curve when it came to understanding the way that federal procurement actually works in practice.
No, that's a good point, and maybe Andy or Justin have something to say on that. But yeah, I mean, they can understand competition law, bid rigging, but many aspects of government contracting, and certainly healthcare, are counterintuitive. And I think we all know that. And, there are some elements, the whole notion behind a strike force is bringing various people with very substantive backgrounds together because the whole is greater than the sum of its parts. But at least my experience, which is very, very limited, is that they sometimes will treat industry is kind of like off the rack, and they don't really view the unique peculiarities of government procurement in healthcare and other industries, even though their intentions may be pure.
So I just resolved a bid rigging case in the context of government contract, an IDIQ contract. But I don't believe that it was actually part of the strike force. So we dealt just with DOJ antitrust on the criminal side, and there were no AUSAs available, and the cases were resolved in a district that was not a member, right, of the strike force. I'm going to take the fifth, as to Jen's question about how about how knowledgeable they are about the government contract issues. But to me, like the whole thing is in a way peculiar when you're dealing with these districts and which cases are kind of within the strike force and not within the strike force. I'm not really sure what the logic is there, but I'm sure there is one that I'm just not privy to. So with that, we'll turn to the next topic, which is the new DOJ guidance. So I'll just going to say a few things. So there were on the corporate compliance program, as many of you probably know, there were some substantial changes to the DOJ corporate compliance guidelines last year in 2019, and we covered those in this event last year. And there was an update again in 2020 that I would characterize as more of a tweaking of the 2019 guidance. There were no real wholesale changes, although a lot of the words did change. So I'm just going to, I think, focus on two changes. Well, the first thing I'll say is that, in terms of the core structure and the content of the guidance, that remains largely unchanged. There were 3 overarching questions in 2019, and there are 3 overarching questions in 2020. 2 remain unchanged, and those 2 are, is the corporate compliance program well designed? And the other is, does the corporation's compliance program work in practice? The one that changed is the second question, which is previously, is the program being implemented effectively? And it's now, is the program being applied earnestly and in good faith? In other words, is the program adequately resourced and empowered to function effectively? And to me, that's really the same question. It's just now DOJ shedding a little bit more light on what they meant in 2019 by, is the program being implemented effectively? In terms of the substantive changes to the guidance, there's a little bit more of an emphasis and focus on individualized assessments, whereas the 2019 guidance stated that prosecutors should make an individualized determination in each case. The updated guidance goes a little farther and instructs the attorneys, DOJ attorneys, to make a reasonable individualized determination in each case that considers various factors. And those factors include things like the company size, industry, geographic footprint, regulatory landscape, and other factors. And this part I think is key, both internal and external to the company's operations that might impact its compliance program. And so, to me, that just says context matters, right? Including context that is external to the company's operations, like the fact that right now we're in a pandemic. And the second change that I'll highlight is a new and substantially more increased focus on data analytics and looking to whether these compliance programs take data and essentially not only study them and use them to determine whether there are problems, but also to add to the lessons learned from what that data says and continuously improve on the compliance programs. So that is, in a nutshell, the update to the corporate compliance programs. The next update is on FCPA resource, which I think Jen is going to talk about.
Yes, and I'm going to make it really quick because this is the first update to the FCPA resource guide that DOJ and the SEC first put out in 2012. I think there's certainly no way for me to cover 8 years of updates, but so I'm not even going to try. But the resource guide, the second edition that came out in July of last year, is in the supplemental materials that are provided for this panel. And really, that's what it does. It is very nicely laid out and sort of walks through various aspects of the FCPA, how it works, risk areas, touches on the topics mentioned here in the slide. The monitor program and potential debarment, effects of non-prosecution agreements, and that sort of thing. So it covers 8 years of developments. So I did not do a compare and contrast. Just read it. Andy, I'm
Great.
hunting back to you. Let's talk ability to pay for 2 seconds.
Sure. Yeah. So ability to pay. So, this has been something that's been available to, defendants for a long time. In 2019, on the criminal side, DOJ put out in writing a policy on what needs to be done in order to establish an inability to pay defense. And in 2020, the civil side issued one. I'm not going to go over all of the criteria in the interest of time, but there is a September 4th, 2020 memorandum that should be in the materials for this conference that lay out the relevant factors for assessing inability to pay. And it essentially requires a lot of compilation of information and filling out forms and certifications and the like, but it is a somewhat painful process to
Yes,
go
that's well
through,
put.
right?
Yes.
Sounds like, Justin, you may have some recent experience.
It reminded me I'm grateful I'm not an accountant to go through the exercise, but we work with many good ones.
Right.
Yes.
Right. And I recently went through it on the criminal side, and it was, and it's difficult because a lot of these companies that don't have an ability to pay also, aren't going to
Don't have this at their fingertips.
Exactly.
Yeah.
So, and with that, we'll turn to the next topic. Criminal procurement fraud development.
This we'll try and make this our fastest slide today. Individuals are still within the crosshairs. That has not changed. We obviously a lot of attention to that with the Yates memorandum a number of years ago and Rod Rosenstein's follow-up comments regarding it. It's particularly in some of these more significant criminal cases with criminal undertones, you see resolutions involving individuals either civilly or criminally. Quantidine was a bribery case. I think back a couple of years to the ADS case where the CEO had a very significant personal settlement, former CEO in that case relating to the small business program for fraud allegations. So expect more of that. I wouldn't. I think that will continue to be a part of the landscape.
Yeah.
No question.
All right.
The one thing I would add to that, this doesn't go to criminal procurement, but in the FCA world, I mentioned the Purdue settlement. Obviously, that's a humongous settlement that they're poised to complete. But interestingly, the Sackler family, the owners of Purdue Pharma, have entered into a settlement, or at least are poised to enter into a settlement for their individual liability. So in that case, although it was civil, the government didn't merely want to hold Purdue accountable, but made an absolute point to address what they viewed to be the culpability of the Sackler family members as well. I think that was noteworthy.
So let's turn to the next topic. FCPA developments. Jen?
Yeah, so this whole panel is supposed to be like half the FCA and half the FCPA, right? We're not doing that. I think for this particular audience, in thinking about FCPA developments, there's the sort of the headline news that, again, we're circling back to those stats. So there's a reason that Bob got so much time to talk about the FCA stats. So here with FCPA, DOJ and the SEC have a fair amount to brag about. They brought in 2020, $6.4 billion in FCPA recoveries in 2020. So, the FCA, that sort of dwarfs the FCA statistics. And it's a great, bragging rights line on FCPA. But a little bit like the False Claims Act statistics, that figure, that 6.4, it goes to corporate recoveries, and it really is representing a handful or two of cases. There are these blockbuster recoveries for certain cases. I think, again, for purposes of this group in the procurement field, the biggest substantive headline news and development came really early on in January of last year with the Airbus settlement. And it's of interest, it was a global penalty resolution, 3.9 billion around the globe. Nice big headline grabbing number. The penalties that were attributed to activity that occurred in the United States or that related to the United States was 527 million of that great big number. And I think here what's interesting in looking at this settlement and looking at some of the other pieces that were put in place on the US side and for contractors is that in sort of typical FCPA fashion, Airbus was dealing with a bunch of intermediaries. So it was, had third-party suppliers or third-party dealers in different countries that were involved in the improper conduct. So, big implications for companies that are that have an international supply chain or work with third parties in some of our FCPA sensitive areas. They were also, Airbus was also involved in the sale of US defense items. And so separate and apart from the FCPA settlement, there was actually an investigation and a consent agreement that Airbus entered into with the State Department to resolve ITAR penalties, and also to the company did avoid debarment, but that became an issue in this particular context, which was interesting. And it was also interesting and notable. You see this $3.9 billion figure, and it's a little bit breathtaking at how many dollars that is. But the settlement agreement and the State Department consent agreement all made fairly clear that Airbus was very cooperative with the government. And as a result, they did not wind up with a monitor, at least from the United States standpoint. Largely because they shut down the entire operation that was involved with the conduct. I think it's an instructive case again for this crowd in particular because of the issues with the international supply chain and working with third parties and really having that robust FCPA compliance measures in place when you've got those issues. And certainly if you're involved with the sale of ITAR items, defense items. Interesting.
Great.
So.
Thanks.
And I would just add that the FCPA stats like this really show the big difference what would typically be referred to as an outlier can have. In this case, the Airbus settlement, going back to the FCA, again, Purdue Pharma at $2.8 billion. That deal that'll be reported in 2021 is more than the total recovery, FCA recoveries in 2020, one company. The Sackler family, $225 million is 3 times as much as all defense FCA recoveries in 2020. It's just, it's crazy, and then we saw it in 2014 when the financial services industry had $3.6 billion of a $4.5 billion year. So 1 or 2 cases can make a humongous difference. And particularly in the FCPA world, I think we see that quite frequently.
Well, I think
that's
it
right.
goes to show too that the dollar amount of recovery is not necessarily indicative of the enforcement activity that's occurring. Like looking at back at the FCA stats, I always focus on the pipeline because that's, the government's going to investigate those cases in some form or fashion, and a lot of them are going to get left by the wayside. But if the life cycle of an FCA investigation and litigation is somewhere between 1 and 15 or 20 years, and every year DOJ has a couple of big blockbuster recoveries, but they also have smaller recoveries that don't grab the headline news and yet are part of the activity that's going on. So.
And that's a great segue to our next topic, right? So Jen talked about what the pipeline is. And so there's a number of things that we want to talk about what our predictions were for 2021. I'd actually like to start, since Jen was talking about pipeline, about CARES Act cases, right? And what we expect to see, because I would imagine that many of the folks participating in this conference may have gotten PPP loans, for example.
Yeah, well, and I think all of the news alerts, client alerts, and articles are coming out this week about the first False Claims Act and FIREA settlement for PPP loan fraud was announced by the Eastern District of California on January 12th. Was that last week or the week before? One of those weeks. And it was a tiny settlement at the end of the day, but the company and its owner were both on the hook for causing the PPP lender to make a false claim for its lender fees that it got from the SBA. It was only $17,000 and some in lender fees, but that was the hook to False Claims Act liability. I think we might see more of that. Anytime that the federal government is throwing out literally trillions of dollars to try to stimulate the economy or to keep the economy afloat and to give people relief, you're going to see people abusing. There's money out there and there are going to be abuses. It's going to be very interesting to see how those play out and the rapidity with which SBA and Treasury are putting out regulations to try to guide people about how to approach those funds and how to take advantage of the programs that were put in place. I think is going to give the defense bar a lot of fodder in the future, but it's still activity and it's still those transactional costs of having to respond to the inquiries and respond to the investigations. And the relators bar is salivating over all of those dollars that are out there, and their phones have been ringing off the hook, just like the OIG hotline phones have been ringing off the hook since the CARES Act. So we're definitely going to see it. It's going to be interesting to see exactly how it plays out and how much time it takes for those cases to play out.
Yeah, it's interesting you say that the relators bar is salivating over this, right? Because in relative terms, a lot of these cases I think are going to be, relatively small dollars, and because these FCA cases are, probably 99.9% are taken on contingency fee. Like what is in it for the Relators Council other than perhaps being motivated by the chance to recover their attorney's fees, right, at the end of the day.
Yeah.
Yeah,
no, that'll be definitely interesting to see how that one plays out.
Right. And I think though that given how the program has rolled out and a lot of the kind of ambiguity and confusion around what the rules are, it's going to be interesting to see how these really play out on the merits. So you've got just the kind of, confusing issues around like the affiliation rules, right, and eligibility for be. But you also just have other things that are coming out as kind of seemingly new rules, right? I was just looking the other day. I had to look at I think it was the January 6th interim final rule for the PPP loans and forgiveness. And even though the preamble says that, it's really just, it's not meant to make any substantive changes, there are brand new requirements in there that are nowhere in the statute, nowhere in any of the previous FAQs, and they're big issues, like not small issues. Yeah. And so, what the relators and the government do, we'll have to see.
No question about it. So on my list of here, I've got my favorite domestic preferences. Early in my career, I remember the office products cases kind of hit the airwaves. The subpoena cases, not non-compliant trade agreements, actually, tables, Office Depot. So it sort of resonated with me, and you've certainly seen, this has been a mainstay, right? In the GSA schedule, you're selling products that are made in China and so forth. So obviously, I think this week with the president's and the prior administration, there was this huge expectation of a Made in America push and enforcement. There's a lot of bluster, maybe, and not a lot of execution in the former administration on some of that. But I think with the president's executive order earlier this week on the Made in America laws that came out on the 25th, likely to prompt some rulemaking, instituting a new Made in America laws director, overseeing this. This is an area where I think I'm predicting you'll see a little bit more scrutiny and focus, and some of it maybe, heading off from kind of the contract administration that we think everything should be resolved into false claims investigations. Right.
Well, I think anytime you see a lot of changes, right, a lot of changes in policy and the rules and things like that, you're going to see, a lot more traps for false certifications and the like as the rules are evolving.
Yeah, I mean, Defense Production Act, right? As a corollary to that, you see, I've had a lot of outreach from clients that are dealing with how to navigate rated orders, and it's some of these things. These are complicated things, right? I mean, this is which we're grateful for because we get to make a living trying to figure it out. But I think it's going to be a ripe area for enforcement.
Right. Well, another area that's ever evolving is cybersecurity, right? And the certifications on that. So. I know Jen had some thoughts on that.
Yeah, well, and my guess is that folks in this crowd know that this has been a big push for the last several years from DoD as DoD is moving from the current contract clause, or what was the contract clause approach, into the CMMC sort of third party certification approach. And this year we saw, end of November, the new rule went into effect that requires contractors working with DoD and who are dealing with certain types of information, the CUI information, to undergo a self-assessment and to report into Espers what their cybersecurity scores are. And from an FCA lawyer's perspective, self-certification is always fraught with potential to make misrepresentations, either knowingly or mistakenly. And here, it will be interesting to see how this plays out, because it's again, rather than signing up to a contract clause, contractors are now going to have to affirmatively certify and report, and the government will have that information available to it at their fingertips through Espers. So, do it right.
Right. So another area that we've seen a lot of, or I won't say a lot, but we've seen more activity is in cases that go against private equity investors. And I'm kind of curious what the panel thinks is behind that. Is it just that they're a deep pocket, or is it that they were actually responsible, or that they were driving the alleged fraudulent activity? Any thoughts on that, and whether we're going to see a lot more of it in the coming years?
Well, I think it's all of the above. I mean, I think there's been an explosion of private equity activity. Generally, it's an important source of capital in the country, and a lot of people are attracted to the virtues of this industry. So, in healthcare as well, it's obviously a major, healthcare in particular is going to be a huge part of our economy going forward. So, you look at some of the recent cases, we've got the Gores Group settlement here. I confess some ignorance to exactly why, what sort of knowledge they may have had. This was a business that they'd made an investment in, and the allegations predated their involvement. So, what did they know? What was their involvement in the actual underlying fraud case? Is interesting. I think the other big one was the Medrano decision, where you had a private equity investor that came in, and there were allegations that they were involved and had knowledge of the scheme there that ultimately resulted in the settlement. So I think it's a spectrum. I mean, obviously, if you're a PE investor, you're advising a PE investor. I mean, and look, most people are focused on diligence and making sure that they've got their arms around it, and we run a compliant business, but it's got to be more than lip service. If there's, if you've got a problem and you've got some connection to it and haven't paid attention, these things just confirm that you're absolutely going to be in the crosshairs.
Yeah, you can't just be a quiet observer.
No,
So,
if you're going to
right.
observe and you want to be involved and you want to drive, improvement in the business, you're taking some ownership.
So I think we're just about out of time, just a minute, but maybe I'll give Bob the last word about anything what would you say is what we're going to see in 2021?
Well, I think what's interesting, since we're kind of in Washington, is what the new administration, how, if at all, that will impact FCA, FCPA enforcement. I don't have the answer to that. I do go back and I recall when then Attorney General Barr had I think it was in 2019, he had to walk back some comments that he had made where apparently previously he viewed the False Claims Act as being a quote abomination and unconstitutional. I was kind of hoping that would result in a much bolder exercise of voluntary dismissals under Granston. It did not. I mean, we still, 50 was a lot, but not that much. I think we're not going to see a decrease in the government's appetite for fraud enforcement, whether through the FCA or FCPA. I think there could arguably be an increase. And as we saw in the stats, I mean, don't rest too easily based on some ho-hum numbers from 2020. I think there'll be a lot of robust activity in 2021. And I think those of us on this call will be fully employed. So.
All right. Well, unfortunately, I think our time is up, but I want to thank Bob, Jen, and Justin for joining me today, and thanks to PubK, and enjoy the rest of the program. Alan?
Andy, thank you. And let me add my thanks to you in particular for organizing the panel, and to Justin, Bob, and Jen as well. Outstanding contributions, covered an awful lot of material. We know we're compressed for time, but we appreciate it.